Yes,
We are on.
we are on.
Good morning again. This is time and place set before the Taxi Cab Authority for a workshop to solicit comments on amending and repealing regulations and to determine the impact of proposed regulations on small business. Let the record reflect that present are members Decker, Graff, and myself, Vice Chair Soderberg. I don't believe we have at this point any other members online, but I've been advised we do not need a quorum, so we will just move forward. The next item, we do have to have a public comment section, so I will hold the floor open for public comments. Public comment is welcome, limited to 3 minutes, to be on the regulations that we have before us. Any other items would have to be re-agended at another meeting of the board. Are there any members of the public present in Las Vegas who would like to address the board? Let the record reflect that no one has come forward and that we have no members of the public currently online. Okay, discussion. Ms. Webb, this is where I hand this over to you and start to relax.
I'm glad I could help. Okay, so we've gone through our the requested changes before. Today, we're just going to go through the newer ones. Everyone has a packet. They're up front at the table. You will see on page 1 in the blue, that is the entirety of Chairman Reeser's request from last time, that section 2, that we remove the uniform system of accounts from the NACs and have our own manual. That way, when we need to change things, it's much faster and quicker. So that's virtually almost the entirety of page 1. At the bottom of page 1, which is called section 3, Chairman, bless you, is Chairman's Reeser's potential changes as to how we pick a chairman. And that's what we put in there. I don't know if you want to discuss or just me move on.
Does anybody have any, on the board, have any comments regarding what Ms. Webb has given us so far?
No.
Oh, yeah.
Do we want to insert the word interim before chair in the first sentence of 3.1? As chair of the authority shall select a member to serve as the interim chair. Was that the intent?
I was the actual chairman
Okay.
board was his intention. But if you want to add something else regarding an interim, I'm certainly okay.
No, let's leave it out for now.
All right. The other changes we made from last meeting are at 486, which I have at the top of page 6. Last time we had some strikeouts, and after we had a staff meeting, we removed some. I'm going to tell you what those were. We had struck the entirety of 46 1C. We have removed the strike, and now we intend it to read as display. Sorry. Display the taxi cab unit number within each taxi cab and a location plainly visible to all passengers.
Why would the cab company not want the telephone number?
not sure I can answer.
Okay.
Member of industry would like to answer, Member Decker?
Risk Freights, Desert Cab Company.
We just need you under those
Right.
high-tech microphones.
So Rich Freights, Desert Cab Company. We don't currently have the phone numbers on the side of the
You
cab.
know, okay.
And then previously in 1B, we had removed the language sides of both front fenders and this time we are removing that strike, so it will read display in bold block letters not less than 4 inches in height, the unit number of each taxi cab on the sides of both front fenders and on the left rear of the taxi cab in plain view in a color contrasting with the color of the taxi cab.
That's because of the hatchback situation, not the trunks.
525, page 12 on mine. We are changing that to a permit that has expired may not be renewed. They can apply for a new permit. That's what that means.
Quick question for the administrator on this one.
Yes, sir.
So you're going from an annual permit to a biennial permit?
Yes.
Is there a fee for the permit?
Yes, there's a renewal fee.
Have you calculated the fiscal impact?
I'm going to defer to Mr. Mel on that.
Because you're going to be collecting half the fees that you would
Yeah.
normally collect.
Yeah, Curtis Mel, for the record. We are looking at increasing that fee. That is an NRS. That takes a little bit more to do. But it is an impact. It isn't a large impact. We do, on renewals, we do about 4,500 renewals a year. So if we go to a 2-year, yeah, it will impact it some, but it's a smaller amount right now, but we hope to be able to raise our prices on the cost of it.
But you would have to do in 2027.
Yeah,
Because it's too late to do it in the 25 legislature.
yes,
So for 2 years, you're going to cut those renewal fees in half.
on that portion of it, on that. The new, a new applicant is $40. So we still get that revenue on that. There's no change there. If we go to a 2-year, we're hoping to then bring more people in as well and have more new drivers coming. But we still have a lot of expired ones that still get charged at the $40 as well. There is a small impact but it's negligible.
Good morning, Cheryl Gibbons with WHC for the record. I'd like to backtrack to 706519 if we could. For the driver's physical, it was valid for at least 2 years. Although drivers were being issued physicals for 3 months, 6 months, a year, the authority had agreed to allow a 1-year certificate. But in the reading of this valid up to 2 years, are you saying now that you will accept a driver's physical that is only valid for 30 or 60 days?
Yes. We're trying to get away from the really short-term ones, the 3 months or less. So,
But with this language, it would allow that, the way this reads, because it says, the new language says valid up to 2 years. So if a driver was issued a certificate for only 1 month, it would be a valid DOT certificate for purposes of this. And I wasn't sure, based on our conversations, that was not what you were looking to do.
no, that's not what I'm looking to do.
So valid for at least 1 year would be my suggested language.
I'm sorry, what was that?
It would then just say, instead of it being in red, valid for at least 2 years, you would just say valid for at least 1 year, if that's what the authority's intent is.
Well, the intent is to try to get rid of the really short-term ones. I was just asking Ms. Webb if we can do that through policy. If we can do it that way.
Thanks.
May I?
Yes.
Good. Curtis Mel for the record. So we are aware currently of how we have it. We do have a policy, an internal policy that the administrator has signed that mandates that they have to have a minimum of 1 year based on our 1 year renewable license. Because we had a large problem of people coming in with 3 months. And by our statute, it said we needed to have a 2 year medical certificate. So we did it. We moved it down to the 1 year, trying to get people, healthy people in behind the cabs. So we put a policy on there to do that, but then we would move people to a temporary status if they did go below that year, and then would make them come in every 90 days to get it renewed to try to encourage them to get that 1 year minimum.
So I think what we're trying to read together is 519 and 525.
What, I mean, I'm just going to throw out that I would recommend that you try to match the NAC with policy and what you're looking for. You could say for a minimum of 1 year, for at least 1 year, unless exempted by the administrator. That would give you some discretion to temporarily authorize shorter ones if you wanted to.
And I do want that authority too, because if it's a long-term driver that has a short-term problem and a doctor is only going to give them a 30 or 3 month or 6 month, I'd like to be able to keep that driver driving if it's safe.
So that was to 525,
519.
519.
And 5.
I'm sorry.
And
Yeah. Remember Decker's comment was make a match.
And then to accomplish the uniform system of account manual, which we will have to present to the board, we are going to remove at page 22 through 50, NAC 706558 through 855. In just a moment, Ms. Maxine Rushton is going to come up and we're going to talk about changing some of the rules of practice in front of the taxi cab authority. On the paperwork you have before you, on page 53 at 885, we struck out interested party and we struck out 1E. And then Ms. Maxine has some other comments.
Sorry, were we done with the system of accounting?
Yes.
Is there something that's taking its place?
We're going to, page 1, we're going to have an in-house manual,
Oh,
and that way we
Manual.
can just change them with the word authority.
I got you. Okay. Sorry, while we're waiting, for your in-house manual and the change, are you including a penalty for,
The in-house manual will mirror what we have now, and then we're able to make changes in front of the board.
but the in-house manual doesn't have the same authority to require companies to adhere to it, does it? Or does it? And is there a penalty for not adhering to it?
To the uniform system of account.
Yes.
I'll
So
look at that while
currently, the uniform system account is in law, in the code,
Yes.
has penalties for not complying. So if you're going to refer to an in-house manual that the agency will create, you may have to include the same penalties for not complying with it that are currently.
Let me look at that while Ms.
Okay.
Maxine.
Okay.
Well, and for the record, Kimberly Maxon Rushton on behalf of the law firm Cooper Levinson and appearing on behalf of the Livery Operators Association. In response to your question, Member Decker, what I think Chair Reeser's thought process was here was akin to in gaming. We have technical standards and we have minimum internal control standards. And all of those are set aside from the regulations, but the regs refer to them and the obligation, as you noted, of the licensees to adhere to them. But it gives them some more flexibility. Now, gaming doesn't have the same obligation that other agencies do to go through LCB for regs, but it still gives them the ability in the industry to bring it forward and say, we need to make these technical changes because of where we are with technology. Minimum internal controls may work for one company, but not for the other. We need to do that. So I suspect that that's what he was looking to do, and I can assist Ms. Webb if it's acceptable to the board with kind of tying that language the way that you'd like to see it, so that it's a living, breathing document that the industry and the board can work through together, but it ties with the same obligations as any other regulation.
Thank you.
Yes, thank you.
And then following through with respect to the changes, some additional changes that we talked about at the last workshop, specifically were changes to the practice before the procedural practice before the Taxi Cab Authority Board. And while there's a lot of the provisions squarely with what the industry understands and knows and currently, follows and seems to work very well, what we talked about was possibly adopting some more specific standards as set forth under the Nevada Transportation Authority's rules. When Ms. Webb and I met outside of the workshop and went through those, we realized that there's a lot of redundancy. There's also a lot of regulations that you have in place that may otherwise could cause confusion. So what we tried to do is really tailor it to specifically practices that would make it more clear for industry members and interested parties to participate, and then also let them know what their standards are. And so with that, if I could, I'd just like to walk you through some proposed changes that I would recommend. And again, I've gone through these with Ms. Webb, and it's specific to the language that's already in the regulations before the NTA. And again, as you may recall, Chair Reeser said just adopt it by, reference. And what we thought is, again, it would be better if we went through these and kind of streamlined them to match up to your current regulations. So I would propose as the first regulation for consideration is adding the standard that's currently before the NTA relative to the reliance on Nevada rules of civil procedure. Meaning if it's not covered in here, we'll look to the rules of civil procedure and follow those standards. So it's one in which most practitioners can easily follow. We know what the timing is, but every once in a while, something comes up that's not otherwise addressed in the reg. It gives you a point of reference, and it's done, like I said, in multiple other state agencies. And specifically what it states is that if something is not otherwise governed by the procedural standards before the Taxi Cab Authority Board, we'll refer to the Nevada rules of civil procedure.
Where is that?
So it's currently contained in 706.3933, and that's under the NTA standards, member graph.
Those are not.
But we're going to reference it in ours?
That was the plan, yes.
Is it,
But it's not in here yet. Okay.
So what we thought we'd do is, based on the fact that the language is already codified, I go through and kind of explain the intent and what the objective is and kind of give you a understanding of the language, adopting it specifically, and then again, not having to go through another workshop, but putting it in front of the LCB to see if they have any heartburn, and then it comes back for you, as you know, for additional consideration and adoption at that time.
So would we be just adding it to NAC 706-876?
Yes.
Okay. Seems like that's where it should go, maybe.
Yeah, since we don't have an NAC specifically, we would add it at the front like we did Chairman Reeser's. And eventually LCB will put it where.
Okay.
The next provision I would recommend for consideration is just the definition of relevant, specific to the evidence that's presented before you. It's a generic standard, but it's specifically defined as in reference to evidence or information, means that evidence or information is directly related to the subject matter of the proceeding and has a tendency to make the existence of any factors of consequence to a determination by the presiding officer more or less probable than it would be without the evidence or information. It's consistent with most standard relevancy demograph and other, in terms of how the presiding officer looks at evidence.
And again, that's not in here yet. This
No,
is
sir.
something that you're going to propose and we'll see next time at the next
At the board.
board meeting.
Good morning, Member Weekly.
Let the record reflect we've been joined by Member Weekly.
So will we be adding that to 706-9?
My recommendation,
4A.
Member Graff, is that it go after, probably under the section pleadings, motions, or other papers, just because it ties directly with that and as well as the hearing. So, but again, most of the time, LCD makes the determination whether they want to stick it, for lack of a better term.
Okay.
Also, in addition to that, we wanted to propose for consideration language that defines the rights of the parties, and that's specifically identified under 706.3939. And again, that's not in your section, but it is under the NTAs. And what that states is that before any proceeding of the authority, each party is entitled to make an appearance, introduce relevant evidence, examine and cross-examine witnesses, make arguments, and make and argue motions, and generally participate in the proceeding to the extent allowed by the presiding officer. Again, it just gives notice to a party as to what the expectation is in an administrative proceeding before the Taxi Cab Authority Board and or an administrative attorney or administrative law judge. In addition to that, we also talked about the fact that, as you know, the Taxi Cab Authority Board is subject to the Public Records Act, open meeting law requirements, and as such, information that is filed with you is automatically deemed, with limited exceptions, to be open to the public. You have the provisions that are statutory in nature that require that Social Security numbers, bank account numbers are automatically deemed confidential. You also have statutory provisions that state that if it's a trade secret or proprietary information, it's automatically deemed confidential. However, there are often times that an applicant or another party may deem their information to be confidential, and it doesn't squarely fall within those statutory exemptions. What I would propose is that there is a general standard in front of the NTA identified as confidentiality of information, and it allows a party to request that their information be deemed confidential. It has a procedure which accompanies that. So if I'm an intervener in a matter, an applicant has proposed that the part of their information be deemed confidential, I, as the intervener, can come in and say, I'm identified as a party, I want to be privy to the information, and then it gives the presiding officer the ability to determine how much of the information should be deemed confidential, and if there are other procedures, such as non-disclosure agreements or confidentiality agreements, that the parties can enter into so that the information can be shared.
That is 3949 from the NTA.
Yes, ma'am.
And where are you proposing that we insert that?
That would likely go under your motion practice pleadings.
And Mr. Chair, when that falls in lines, or should I say that falls in accordance to our current policy, if you will, it aligns, if you will.
It aligns and it beefs it up so that we have more power.
Yeah.
And I think it aligns with NTA's 706
Yes.
provision. Okay.
I also think, Member Weekly, that it provides clarity to the parties as to how they can request the information and what the policy and procedures are to do so, versus just saying, I want it marked as confidential, and then it goes into a black hole until somebody says, well, I'd like the presiding officer to reconsider that. So having a streamlined policy always gives the parties an opportunity to exert their requests and their rights without any confusion as to what the hearing officer's decision is.
And to me, it sounds like it alleviates bureaucracy.
Yes, sir.
Yes, absolutely.
And then just to wrap up, the other two things that we, Ms. Webb and I discussed that we thought would be important for consideration is defining petition and defining motion. Petition separate and aside from a petition for leave to intervene. Your regulations already address that and have a specific procedure associated with it. But under the NTA, the general practice is that if you want to ask for relief from the NTA, you submit a petition. Could be a petition to change regs, could be a petition to reconsider a board order, things such as that. However, if you have a matter that is pending, you file a motion. And so the petition fees are $50, the motion fees under the MTA are not, because the matter has already been filed as an application, that fee accompanied it. So what we propose, and Ms. Webb and I discussed, is defining petition, separate and aside from a petition for leave to intervene, defining motion, consistent with what I've just represented, and then the answers and responses to those. So you have a response to a petition, you have an answer to a motion. And those are consistent with general practice procedures. And again, it just gives the parties a clear understanding as to what their authority is and how they can proceed in an administrative process before the TA.
And Mr. Chair, so I'm sorry. And the $50 number, would that remain the same, or is that number looking to change, or?
Well, for the record, I'm Kimberly Maxim Russian. One of the things that Ms. Webb and I discussed is the fact that right now you have an application process and it allows for the imposition of a filing fee, but it's specific to a certificate of authority. You also have authority or a regulation, Member Weekly, that specifically states that you have an application for miscellaneous authority, but it does, in that instance, you wouldn't be able to recoup or charge the filing fee. What I propose, and I think this is part of the discussion that we had earlier about, where the budget is, we're probably going to need to go to LCB or interim finance and say that a petition needs to have a filing fee of $50. A motion goes with an application, the application fee we need to increase. Those things, I think Member Decker would offset the cost relative to the drivers. And that's, again, I just have to champion Administrator Park for that because it certainly does help the industry, but we recognize that every little bit counts. As you mentioned, Vice Chair Sotomayor, about looking in the cushions. So this is a way that with respect to the increasing the imposition of a filing fee, and it's not exorbitant, so it wouldn't prohibit an interested party that wasn't represented from participating.
But was that addressed in any of your proposed changes that you presented here today?
Well, they have those set forth under the NTA standards. So we start without having a filing fee associated with them, but I think that it would result in a request for interim finance. And again, one way to help your budget.
So how do you square that with the change that you're making to 706-885?
So the classification of the parties, the changes that we've proposed, Member Graff, would not in any way, and we can, well, let me say, it doesn't, these changes to 885 do not in any way conflict with the proposed changes that I've requested today. What we can do is we can, again, under definitions, define protestant or commentor, but I think what Ms. Webb's position was is that those are already identified. And correct me if I'm wrong. Oh, no. Okay. So what we were trying to do, Ms. Member Graff, is specifically allow a party or an individual who's not a party to the matter to come up and speak. And so under the NTA, you can be a protestant either by verbal comments during a hearing or pursuant to written comments. This is just trying to mirror that. It doesn't conflict with any of the regulations or regulatory proposals I've submitted today.
Where is protestant or commentator defined? Ms. Webb?
I don't have NTA in front of me either.
So commentator or commentor is not noted under the NTA's provisions, but they do have the protestant. And that is not defined under their specific reg definitions. It's defined under their rules of practice. I'll read that to you.
So, yes, and on our proposed changes at 885, we had added a paragraph 2, which just says we may allow an interested person to participate as a protestant or a commenter. Whose participation will be limited to submitting written comments. That's where we put that last time.
So that's it.
That's what we, yeah.
So Member Graff, that actually does square up with the provision under the NTAs, which is identified as classification of parties, whereby it specifically identifies parties as applicants, petitioners, complainants. It then talks about an intervener is deemed to be a party, even though they're identified as an intervener. And then it talks about a person allowed to petition. So what we could do is adopt that language to include a protestant and commenter or just identify it as a protest since we've got that already identified under other provisions in 706.
Okay.
But the,
I'm thinking mainly just so you know my thought process,
Yeah.
I'm just thinking mainly about general public, you know, when we have public comment in our agendas, we can't take action on it. So now we're trying to create an instance where we can take written comment and take action on it on a particular motion or application. So I want to make sure we
yes, sir.
circle that around so that we can, that the people in the public or whoever want to make a comment, want to participate in the decision-making process. We have, an issue currently on the agenda that the public may have an opinion on. So I want to make sure that they have the ability to contribute and provide written statement as to that.
That's the intent.
Okay, that's it. That's all I have on that.
That concludes the presentation of the LOA's proposed regulations, and happy to answer any questions that the board may have.
Thank you.
That is the end of what we changed from the last workshop.
Does anybody else in the audience would like to weigh in on staff's proposed regulation changes? Let the record reflect nobody's come forward. Next is a discussion concerning the impact of any proposed changes or repeals on small business. Do we have a small business impact statement in our file here?
Could be. Oh, she might.
Oh, there we go.
I don't think. I got it.
Oh, I've got this. So we have a questionnaire. We don't have a statement yet.
We have a statement. Is that it? Is that the completed one that Todd did?
This is the questionnaire, which you had given me a copy of beforehand. I haven't seen a small business impact state draft. Small business.
We mailed it to the industry and we emailed it to you, but we might not have made copies for the binder.
Okay.
Thank you. And it's on our website.
Okay, thank you.
That's what you emailed us yesterday.
I have one copy. Do we need to take a break so we can have copies for the rest of the board?
Yeah, let's take a quick break. And
Okay, we'll go off the record for a little bit and make copies of this.
Yeah, thanks.
How long?
10 minutes sufficient?
I think so.
Okay, so we'll be back on at 11:45. Thank you.